Okay, so you're probably wondering why I look like this. I walked into a lamp and I just moved and I can't find my razor, so I look like He-Wolf. Anyway, I'm Kyle Scott of Smoking Robot and got a pretty big one today. So the U.S. Copyright Office, let me get straight, the United States Copyright Office out of Washington, D.C., has declared that MidJourney AI-generated images are not protectable by copyright. And they've issued a long letter to a creator who applied for a copyright on her comic book using exclusively AI MidJourney generated images, and they explained how they reached this conclusion. And this now sets the precedent today that all AI created images are not eligible for copyright. Now, this might get fought in the courts at some point, and this might get changed as technology advances, but this is a big deal and one of the first, I don't want to say legal rulings because it's not a court, but one of the first regulatory rulings we've seen come down in black and white terms about what is and is not considered copyrightable material output by artificial intelligence. So let's get into this. All right, so what you're looking at is the letter sent by the United States Copyright Office to Christina Castanova, who wrote Zarya of the Dawn, a comic book. It looks like this. All the text she wrote, so she says, she claims, and she arranged all the images. But the images, importantly, were created by MidJourney. In fact, she kind of put her name and MidJourney on the book's cover, so kind of telegraphing one to the Copyright Office there. But anyway, so here's what happened. So she applied for copyright back in October and was initially declined. She was declined because she did not disclose that she used artificial intelligence to create any part of the work. And what's even more interesting is that it turns out the Copyright Office figured this out when they went on social media, not as part of her application. So she didn't tell them that she used MidJourney to create the work. But anyway, her and her lawyer fought back, and they claimed two things. So her lawyer is Mr. Lindbergh, argues that the work's registration should not have been canceled because, one, she authored every aspect of the work with MidJourney, and this is important, serving merely as an assistive tool. So think Photoshop, think a pen, anything can really be considered an assistive tool. And two, portions of the work are registrable because the text was authored by her and the work is copyrightable, compilation due to her, this is also important, creative selection, coordination, and arrangement of the text and images. So what they're basically saying here is, yes, she used MidJourney to create the images, but it was really just an assistive tool for her to create the images. And what's more is she actually arranged and laid out the text and images in a certain way, which is a creative work that itself is copyrightable. Okay, so let's go through this. This is the legal standard the Copyright Office says it's going to use to determine if her book is protectable under copyright. And they're going to reference, I already highlighted some of this, the Supreme Court. And so the Supreme Court has explained that the term original in this context consists of two components. It has to be independent creation, and it has to have sufficient creativity. So they want to look to see that if she was actually the creator on her own here, and if also it required sufficient creativity. So if you just like take a paper clip and stick it on a table and call it a work of art, that might not say, can be considered sufficient creativity. I don't know. I'm just making up an example here. Anyway, they talk about things like photographs. They said people have brought this up with photographs in the past too, saying, well, wait a minute. Photographs aren't necessarily creative work. You're just sort of, pressing a button and making an image representation of something that already exists in nature or some object. But they're saying, no, there's a sufficient amount of creativity there because, someone has thought about like how to frame that image and how to, compose it, right? And there might be examples. The court explained that if photography was merely a mechanical process, right, with no place for novelty, invention, or originality by the human photographer, then in such cases, there is no copyright protection. So they're saying photos are copyrightable because it's up to the photographer to actually kind of do something with that and have expression in the way they show the photo, the way they edit the photo, black and white, heavy contrast, things like that they have great intention when they create the photo. But if it's just a purely mechanical process, then there is no creativity there. And that's where they're going to kind of come back to in a second here. The other example they gave is they held that a book containing the words authored by non-human spiritual beings. So I think this was like the Book of Revelations, like some sort of scripture or whatever. And they said you actually can only gain copyright protection if there is human selection and arrangement of the revelations. So basically, it is copyrightable if you arrange material in a certain way, but if you didn't create the material itself is not copyrightable. So again, we'll get back to both of those things, but this is kind of the standard they're looking at. Is there one independent creation? Is there sufficient creativity? And then the examples they use are a photograph, most of which are copyrightable, but not if it's a purely mechanical process. And then the sort of Book of Revelations thing, it's you can protect the way you arrangement, but not the actual works. You can draw that distinction. So here's what they say. Okay, first of all, the comic book's text is protected by copyright. She wrote it. She said AI was not used. They believe her. They don't think it was used, so therefore it is very obviously copyrightable. That's the easiest one. Two, the selection and arrangement of the text and images. What they're saying here is it doesn't really matter if the images themselves are copyrightable, but the fact that she selected the text, created the text, took images, paired them together, put them in a certain order to tell a story, that process itself is copyrightable, the definition of a compilation. So that is also eligible for copyright protection. However, number 3 here, and I don't know why it's labeled D. Whatever, it doesn't really matter. Maybe it does, but so turning to the individual images in the work, the office must consider the impact of Ms. Castanova's use of MidJourney's artificial intelligence technology in its copyrightable analysis. So what they're going to do is look at how MidJourney works and use that to determine whether or not this thing is eligible for copyright. So they kind of go on this long thing about how MidJourney actually works, and they show examples from its Discord channel. I'll kind of save you the boring detail, but for those of you who don't know, the way most of these AI image generation apps work is you give it a prompt. So here's an example of cute mini dino, kindergarten, coffee taster, 3D realistic detail. There's a lot going on there, but essentially you're giving the MidJourney, in this case, a number of keywords, and then it's sorting through its entire database of images and photos that it has and it's collected and that it's tagged, and it's sort of going through each of those keywords one by one in order. This is important in a process called token. So each word is taken as a token. It uses that as a filter. It takes this vast library of information that it has, and it filters each one. So it's like check mark, we got the dino, check mark, kindergarten, check mark, coffee cup, and so on and so on and so on, until eventually it refines the process into the images that you see here, and it gives you a few examples when you ask. It usually gives you 4 results based on the words that you gave it. So that's important to understand going into this. MidJourney does not interpret prompts as specific instructions to create a particular result. I.e., when you give it a prompt, MidJourney is not saying, okay, I understand what you mean. I'm going to go make you exactly that. It's breaking down your prompt into a smaller set of, I don't want to say instructions here, but a small set of words that it's using to then filter its database. So they go on. Because MidJourney does not understand grammar, sentence structure, or words like humans, it instead converts words and phrases into smaller pieces called tokens that then be compared to its training data, then used to generate an image. And what it says is basically filtering a field of visual noise, like television static, used as a starting point to generate the initial image grids, and then using an algorithm to refine that static into human recognizable images. All right, so this is really important. What it's saying is you're just sort of, like the image already exists in there, and then each word you give it, which I don't know if I buy, but the image already exists in there, and each word you give it, it just sort of fine-tunes, dino, got it, fine-tunes, until it eventually gives you something that looks like the image you asked for. All right, so back to it here. So the application of copyright law to MidJourney images. Based on the record before it, the office concludes that the images generated by MidJourney contained within the work are not original works of authorship protected by copyright. And one of the things they cite is that she talks about it's basically the process of trial and error. Because when you create an image, you're not giving it an exact example and saying, make me a picture of a dino in a cup. And what you're really doing is just feeding it prompts, and you're getting a poor result. So then you try a slightly different prompt with a different word, and then you get a slightly better result. And you keep refining, and the machine keeps refining. And eventually, if you just try enough and understand exactly how to phrase this thing to sort of manipulate the AI to do what it wants you to do, you get the result you want. That is an important distinction here for the Copyright Office, because it's not taking your instructions. You're just basically, it's like throwing shit against the wall, and then eventually, you do it enough times, you're going to get the smiley face from Forrest Gump, right? Okay, so let's move on here. So what they say is, rather than a tool that Ms. Cashinova controlled and guided to reach her desired image, MidJourney generates images in an unpredictable way, i.e. like throwing shit at a wall, let's see what sticks. The fact that MidJourney's specific output cannot be predicted by users makes MidJourney different for copyright purposes than tools used by other artists. So then other artists. So then they go on to Adobe Photoshop, which is a very common tool used by artists. And we're like, well, if MidJourney is not a tool that you can use and have a work be eligible for copyright, then why would Photoshop? And here's what they say about that. Photoshop, the user selects what visual material to modify, you choose which tools to use and what changes to make, and take specific steps to control the final image such that it amounts to the artist's own original mental conception. So if I have a Photoshop of a dinosaur in a cup, I could take an image of a dinosaur, I could take a cup, and then in Photoshop I could very specifically carve out the edge of the dinosaur, carve out the cup, drop the dinosaur into the cup. If I want to paint it purple, I could take that little purple paintbrush, make the dinosaur purple, make the cup white, put in a backdrop, and everything you're doing, even though you have to learn how to use the tool, once you understand how to use it, you could pretty much do exactly what you want if you're skilled enough. That is not necessarily the case with AI, where you just keep trying and trying and trying until you get the result you're looking for. Users of MidJourney, back to the document here, do not have comparable control over the initial image generated or any final image. Therefore, it is understandable that users like Cashinova may take over a year from conception to creation of images matching what the user had in mind, because they may need to generate hundreds of intermediate images. So what they're saying here is, it's almost like a bug. It's almost like a feature of AI that it has to take so much time, and there's so much trial and error. And we'll get to the time part, but what they later said is, like, it doesn't really matter how much time it takes you. Just because it takes you a lot of time, effort, or money doesn't mean something is eligible to be copyrighted. But the unspoken part of this is AI is supposed to make your life easier, right? So if you think about AI and art, the idea here is you could say, I want a dino in a cup, and it should spit it right out. But because MidJourney doesn't really work like that, you have to have this trial and error process of understanding how to manipulate it to do what you want to do. What they're saying is, like, this takes you longer. She would have been better served paying $5,000 to a designer to create this in like the span of a week or 2 weeks, instead of like years of just trying and trying and trying at MidJourney. I don't know how much time she spent, but in her letter to the Copyright Office, she actually talked about like how much effort it took her. So anyway, all right, let's move on here. So I'm going to read this whole section. The office does not question Ms. Cashinova's intention that she expanded significant time and effort, but that effort does not make her the author of MidJourney images under copyright law. Courts have rejected the argument that the sweat of the brow can be a basis. That's such an old school term too, sweat of the brow. Like, I love that's something your grandfather would have said. Oh, sweat of my brow. All right, anyway, the sweat of the brow could be the basis for copyright protection in otherwise unprotectable material. The office will not consider the amount of time, effort, or expense required to create the work, because they have, and this is important, no bearing on whether it possesses minimum creative spark required by the Copyright Act and institution. So basically, like, listen, you could spend 100 years on this. If it's not something that we think you can copyright, you can't just brute force it by saying, hey, it took me a lot of time, I should be able to cooperate it. Pretty interesting. So the images edited by Miss Casanova suggest that she personally edited some of the images. Okay, so what they're saying, so let's kind of boil down to how we got to here. What they're saying is, hey, this tool is not an intention-based tool. It's not giving you exactly what you want. Trial and error doesn't make a copyrightable work. Time doesn't make a copyrightable work. So Miss Casanova says, well, wait a minute. Not only did I do all that stuff and think that alone is eligible for copyright, but importantly here, I also used Photoshop to refine those images. So I used two tools, two assistive tools. And if you don't think the first one works, look at the Photoshop work I did. So let's look at it. Let's go to her image. So this is what the Copyright Office cites. They show the before Photoshop and the after. And she says she edited some of the lines in the lips. And if you look, the green doesn't help here, but if you look, you could see that there are minor edits. And the Copyright Office is like, nope. The changes to Zarya's mouth, particularly her upper lip, are too minor and imperceptible to supply the necessary creativity for copyright protection. Basically what they're saying, the new work has to contain sufficient amount of original authorship. And because you added a line or two to the lip and said, hey, you edited it, that doesn't work. Now, if you cut out the lips, you put different lips in, maybe different hair, change the hair color, change the background, change the filter. Like, yeah, at some point you're reaching a threshold there and there's no black or white answer here. It's kind of a gray area as to what that threshold is. But like just this minor refinement doesn't mean that you yourself created the work. They point to another image where she said that she turned this person from a young person, added a filter, and made it an old person in a jar. But she never sent them the original work. And the Copyright Office is like, you know, I don't know, they said it in here, like, we can't tell. You never sent it to us. So we don't know how much you actually did. And frankly, we probably don't believe you. So, yeah, so they don't even take that into account. So they basically threw out her Photoshop argument. And the conclusion is the office concludes the registration for Zarya the Dawn was issued based on inaccurate and incomplete information. Had the office known the information now provided, it would have narrowed the claim to exclude material generated by artificial intelligence technology. So what they say, and it goes on elsewhere in here, it says they're going to give her copyright for the work, which she is taking a victory lap on social media over, and some AI proponents are. But they're saying, but, here's the big but, and we'll backdate it to September when you initially wanted it. All cool. But you have a copyright on the text. You have a copyright on the order of the text and the way you ordered these images. But the images themselves are not copyrightable. And that, I mean, that's a big deal. Because if you think about all of the use cases of AI right now, one of the most popular ones you're seeing on Twitter and Instagram or wherever on the internet in general is the art tools. And frankly, much like crypto and blockchain with NFTs, one of the very early use cases for AI is art. Like, I don't know if it's ironic, coincidental, or whatever, but 2 years ago we had NFTs. This year we have AI generated art. And I think the reason is, there's a relatively low bar to produce these things. It was very easy to throw out with generative art like 1,000 NFTs and put them up for sale on OpenSea and hope it goes for sale. With crypto, with AI, it's very easy to go to one of these tools and say, make me a picture of a water bottle with a clown, right? And the clown is holding a water bottle. And say, look what I made. And people who spend enough time trial and error how to feed these things prompts get pretty cool images, and they can show them off on Twitter and they get a lot of likes and people retweet them. And then like you've seen these people, if you're into AI at all and follow anyone on Twitter, like just all day, they're like, look what I made with MidJourney. Look what I made. It's like, dude, what do you do with the rest of your time? Like, this has no commercial value. And oh, by the way, now it's not copyrightable. So anyway, this is a big deal because, you know, for better or worse, art is one of the early use cases of AI. And if you're an artist who thought, I'm getting really good at these prompts, I can make images, charge people, copyright it. If they take my image, I could sue them, all that. No. You can't do that anymore. And the reality is, if AI was good enough and it cut down on people's time, they would just use it themselves. So if I'm a business owner and I need some artwork done, I might just want to use AI. Now, let's say, all right, I want to hire somebody who's really good at prompts to use AI. But if that's the case, you would just hire an artist. So think about it. If you got to spend $500 to generate an image, I don't know, maybe $1,000, whatever it is, you're a small business owner, would you pay a human where you know you can get a good output? Or would you pay a human to put input into an AI to give you a output, right? Where this will really change is when these art generative tools, and this might happen like 6 months or 12 months from now, are good enough that you put the information in and it gives you back what you want each time. And that in and of itself is one of the most important parts of this. So I want to go back to this one line here. All right, so check this out. So in the ruling, they say it is possible that other AI offerings that can generate expressive material operate differently than MidJourney does. So what they're saying is in the future, as AI gets smarter and operates in a way that is more natural than how MidJourney is. Keep in mind, MidJourney, you give it a prompt, and it takes each word, it parses it, and it refines the picture, and it scribbles a little out, and it says, okay, dino, let's go through my database of dinos. Okay, we got dinos. Let's go through my database of cups. Okay, we got cups. Let's go through my database of kindergarten rooms. Okay, let's got it. They refine it until eventually they've got it close enough to what you want. Then they're like, here's 4 versions. What do you think? And then you could refine it a little bit more as you understand how to manipulate it. But what they're saying is, if this thing gets smarter and you tell it, make me a dino in a cup, and it understands, make me a dino in a cup, and it makes you a dino in a cup on the first try because it's smart. Now, you might not like it, but if I told a designer to make me a dino in a cup, they would make me a dino in a cup. It wouldn't be this process of reverse engineering it. So the Copyright Office is leaving open the potential that future AI image generation is eligible for copyright. So this all might be for naught in a couple of months, a couple of years, or they might find some technicality on the way DALL-E operates. I don't know quite enough about it to kind of weigh in on it here. Maybe that would be a different use case. But MidJourney, pretty much the most popular one right now, they're saying, the way it works, not eligible for copyright. So here's the question I have, and I got some notes here. But here's the question I have. So if and when it does get that good, and it does create the image in a way where you're instructing the AI, then what does it even matter for the artist? You want to copyright something because you want to be able to sell it. You want other people to be able to take it. But if the AI is so good, why would people go to another human to create it if they could just tell the AI? I mean, think about it. You're a small business owner, and I get it today. It's newfangled technology. But smartphones were newfangled technology in 2008, right? And so a 48-year-old business owner in 2008 might not have known how to accept a credit card on their phone. But guess what? I just had a plumber here, right? 50-year-old plumber, and I paid him on credit card and his phone. So like in a decade, the world has kind of caught up to how to use this tech. So maybe not right away, but within the next 5 to 10 years, the average human's going to know that they can just create an image by telling an AI. And if the AI is good enough to give you exactly what you want, then why would you even hire someone? At which point, why do you even need the copyright stuff? If it's so easy to just make it and you really can't sell images to other people in general, I'm sure there are exceptions, then does this even matter? Is this like all for naught? Like, I think we're focusing too much on how AI impacts art and AI impacts search engines because of Bing and Bard and all that. There's so many other use cases, and each one has its own idiosyncrasies. But anyway, the Copyright Office is saying today these AI generated image, specifically from MidJourney, are not eligible for copyright protection. So, let's see if this gets battled in the court. Let's see if they sort of try to push the envelope further. I don't think they're going to. The author here, Cashanova, she's on social media saying this is a win. Look, I got copyright for my AI created book, which leads me to believe maybe she used like ChatGPT wasn't out when she filed this, but some sort of GPT-3 was generative program to create the text. But the point is, she's like, hey, this is a victory. Most of it's copyright. Most of my AI work's copyright, except the most important part that took the most time, which is the images. So that's a pretty big deal. Anyway, listen, if you found this deep dive interesting, we usually don't go this far down the rabbit hole, but I had to put on like my legal hat and go through this. Go to smokingrobot.ai. Subscribe to our 3 times a week AI newsletter. It sometimes has this level of nuance, but it's written for normal people. So if it's smart enough, if you're in business, if you're in tech, if you're a developer, to learn about what's going on in AI. But if you're just a normal person that wants to understand this world and what's happening, it's great for you too. Smokingrobot.ai. Subscribe to our newsletter. It's free 3 times a week. We show you a tool of the day. We give you the top stories, links. It's fun. It's entertaining. It's irreverent. And occasionally it's like smart and nerdy like this is. Also, if you found this interesting, make sure to give us a like. Please subscribe to this channel. I am not a YouTuber by trade. I've been creating written content on the internet for 12 years. I'm really just kind of starting with video. We're up to 1,100 subscribers in 5 weeks, 45,000 views. So I feel like we're doing something right, but leave me a comment. Let me know what you like. Let me know what could be improved. I know the sound, the light, like give me a minute, new place here. Lighting will get better, backdrop will get better, mic quality will get better, editing will get better, all that stuff. So I got that, but something about the content you like, didn't like, want us to cover in the future, please let me know. Subscribe, like, all that stuff. Thanks for watching. SmokingRobot.ai. Subscribe to our newsletter. Bye.